Members, we have a quorum, and this is the appointed time. So, the item on the agenda is a meeting with deputations and the administration. And based on the discussion made on the 17th of February at this subcommittee, I already moved a motion yesterday at the council meeting to extend the scrutiny period of the two amendment regulations to the 25th of March 2015. The legislative timetable is set out as follows. Notice for giving amendments is 5 whole days, and then I am to report to the House Committee on the 13th of March on our deliberation. And on the 17th of February, the subcommittee discussed and decided that deputations should be received at this meeting. So let's invite the administration and the deputations in now. In relation to the two amendment regulations, they are invited to give their views, and the Secretariat has also published a notice in the website inviting individuals and deputations to attend today's meeting and to make submissions to the Secretariat. The Secretariat has also forwarded the submissions to members and the administration. Only 5 deputations have written in, indicating their wish to give their views here today. And there are 5 deputations I'm going to tell you in a moment. The Secretariat has also received 2 submissions from 2 deputations which will not be attending the meeting. The submissions have already been forwarded to members and the administration. All right, the administration has arrived. We see some familiar faces. We have Mr. Christopher Wong, Ms. Diane Wong, Ms. Vinci Chan, Mr. Lee Ka-ki, this one not quite familiar, and Ms. Rita Young, and Ms. Cindy Shuk.
Young
5 deputations have indicated that they wish to attend the meeting, but only 3 has arrived so far. So may I remind representatives, and in fact, you should be familiar with the meetings as you often come here. You may use the earpiece and the microphone, and channel 0 is floored, channel 1 Cantonese, channel 2 English, and channel 3 Putonghua. And to facilitate the work of interpretation, please stick to one language when you speak and do not code mix. And I remind deputations and individuals that the speech you make at the meeting is not covered by the protections and exemptions given under Cap 382 Electrical Powers and Privileges Ordinance. Similarly, the submissions made are not covered as well. And I also like to remind representatives and individuals to pay attention to the various security measures set out in the points to note for members of the public attending electrical meetings or in public galleries. The notice have already been served to the letter issued to you by the Secretariat, and it's also in front of you, and members of the public in the public gallery may also get a copy of the notice from the security staff of LegCo here. Now, in accordance with the list of attendance, I will invite you to speak. I've set the speaking time limit as 3 minutes because I didn't know how many deputations there would be. And if you have written submissions, you're welcome to give us the submissions. The first one to speak is Entertainment Business Rights Concerned Group's Ms. Chen Yun-lin. Thank you. Chairman, members, good afternoon. I represent the Entertainment Business Rights Concerned Group. In relation to this amendment regulation, the sector supports strongly the extension of the renewal period from 1 to 2 years. We do not oppose setting the fee for a license that is valid for more than 1 year at a level which is 1.5 times higher than the fee for a 1-year license. This will help reduce operational costs. In relation to the amendment, which would require the licensee to have temporary absence of not more than 90 days as an aggregate of periods, we have no strong views. However, we find the requirement of the licensee being present on the premises quite rigid, because this will impose a greater administrative burden on operators. And very often, the licensee may be ill, may be deceased, or may have resigned, and the operator would therefore need to apply for change of licensee, and sometimes there is a risk of the licensee revoking the license on its own without informing the operator. And this should be reviewed, because this doesn't facilitate business. The administration should accept the sector's views, which is to allow a number of persons to hold the liquor license. In formulating any policy, the government should pay attention to the sector's voice so as not to reduce our room for survival. Next, Hong Kong bars and karaoke rights advocacy. Deputy Chair, Ms. Anita To. Good afternoon, Chairman and members. On the whole, the sector welcomes the amendments for operators with a good track record. This is good news, as the validity period of a license will be extended to up to 2 years. Then, by proportion, the license fee will be lowered. This will help lower our operational costs and also the administrative costs. In recent years, costs have been escalating, including the wages, rental, utility charges. We find it more and more difficult to, as far as the operating of bars and restaurants are concerned. So recently, we have also heard that the government would consider raising fees and charges on the basis of the principle of cost recovery. Maybe the escalating costs also happens to the government. So the sector is gravely concerned because, as I said just now, realistically, our business costs continues to go up, and if fees and charges also increase, our burden will be increased. So I hope the government would, in considering raising fees and charges, take into account the plight of SMEs and stop any further increase for SMEs and micro-enterprises. I don't think I need to say much here. I think everyone understands in Hong Kong that costs on all fronts are increasing. And I'd like to make another point. In recent years, the government has been tightening its regulation over the bars and catering industry, and our operating environment is getting more and more difficult. This is not a good thing because in every city there are bars and restaurants. Hong Kong is an international city, and there should not be so stringent a so-called regulation regime over our industry.
希望政府將個牌照嘅程序簡化咗啦，就
Now, by streamlining the procedure for applying for licenses, I hope more measures can be implemented by the government to ease our burden, including allowing other personnel to hold a liquor license. Next, Mr. Chi-fung, Central and Western District Council member. Good afternoon, everyone. I need to say at the outset that I'm against all the amendments proposed by the administration this time, because be it Central and Western District, Kowloon City, Mong Kok, and other districts, local residents keep on complaining very strongly for the nuisance caused to the neighborhood in the small hours by bars and restaurants. It's unbearable. In 2012, on the 22nd of March 2012, the Central and Western District Council passed a motion to express dismay over the government's lack of effort in resolving the problem of nuisance caused by ground floor bars and restaurants. And local residents and district councils are disappointed. So in relation to these amendments, they only serve to facilitate businesses. However, in your paper, you make no mention of the nuisance caused to local residents. Can you also represent the voice of the people and do something about the complaint mechanism? Well, the sector just now mentioned that their business environment is difficult, but they have a choice. They could do their business elsewhere, but whereas for local residents, they live in the neighborhood. They have no choice at all. Well, in fact, for the Central and Western District Council, we have so many elderly people and local residents which can no longer put up with the noise and nuisance in the small hours, and they can't sleep. Their children cannot study.
So I think there should be a delineation of business and residential districts. You should think about this. Otherwise, I strongly object to these proposals. And for the validity period, it will be extended from 1 year to 2 years. Do government officials and legislators know that residents have been waiting eagerly for the licenses to be renewed, because at that moment they can go to the liquor licensing board and tell the board their views. And we can only do it once a year, but now the maximum validity period will be extended to 2 years. So we have to wait for 2 years before we can express our views. So you have never considered the sentiments of the people. Now you say that there is a midterm review mechanism. I'm sure it will not be effective, because for the law enforcement agents, most of them are police officers, and when the police come, well, not every time they will judge whether the complaint is substantiated. And if you go to the LLB, I am sure many of the liquor license premises will pass the midterm review. Now, you are introducing all these measures, but they are just here to facilitate business, and the victims will only be the local residents. So I object to the 3 proposed amendments. Next, the chairman of the Institution of Dining Art, Yau Kan Wing. We represent about 3,000 members. and we would like to express our views here. As for the government's proposal, now is proposing that the validity period of the liquor license will be extended to 2 years. We support that because it will help us reduce our administrative costs. And for the proposed midterm review mechanism, it's very useful because with this, the premises will try their best to maintain the performance. Actually, many of the restaurants and bars are operating in a stable manner. It is quite rare that they change their mode of operation or target clients suddenly. And for the fee for 2 years, it will be 1.5 times of the fee of 1 year. We think that is fair and just. And you are suggesting that in the future we can make application electronically. So for the issue, renewal, or amendments of license, we can do it online. That can save a lot of our time, and we can assure that the LLB has received our information properly. And there will not be any mistakes made by actually posting the application. Although the LLB has already started an online operation, that is by placing our notice online. However, I think the government should enhance its publicity in this area so that the public would know that we are making an announcement online, and we will no longer be required to place this in newspapers. The procedures will be much simpler, and that will also help us save costs. Thank you. Another representative hasn't shown up. So let us ask the government whether they would like to respond. Mr. Christopher Wong. Yes, Chairman. With regard to the licensee, as to whether he should be an actual person or a company, previously we have reviewed this. But we think the present practice is more appropriate. Because if a corporate body is to be the licensee, then there will be a lot of difficulties for criminal prosecution, and it will hinder the proper law enforcement in this regard. So we think that maintaining the status quo is suitable. And also, at the LLB, we had another discussion, and the LLB agreed to optimize the reserve licensing system so that we can help the sector. That is, other than the licensee himself, there is a reserve licensee. So in case any problem occurs, the reserve licensee can act on behalf of the licensee. We hope that we can introduce a proper system in this regard later this year. And in the paper, well, some people think that we are just introducing measures to facilitate business. However, in the course of public consultation, which was conducted in 2011, and also during the period afterwards, we have consulted the stakeholders. We are now amending the law in accordance with the views we have collected. We have also introduced measures to handle the issue of nuisance. In 2013, the LLB already introduced a measure to optimize things. That is, if there is a renewal or transfer application and objections have been drawn on the previous occasion, or the bar or the liquor license premises has been a subject of complaints in the past 12 months, then the district council member of the respective constituency where the premises are located will be consulted as a matter of course before the case was put before the LLB. And also with regard to upstairs bars, we have now issued a set of guidelines concerning crime, nuisance, and potential fire danger. The LLB is very strict when it comes to vetting applications from upstairs bars. Some extra licensing conditions will be imposed. This would include conditions relating to capacity limits and measures to abate noise nuisance. So all these are included in the set of guidelines, and the guidelines are already uploaded. With regard to fire safety, in June 2014, we have also added express provisions in the licensing conditions stipulating that the licensees must comply with fire safety requirements at all times. Now, if it's a serious fire safety breach, of course the license may be revoked immediately. Even though the breach is minor, if it's not attended to promptly, it will still render the licensee liable to suspension or cancellation of license. Now, these are administrative measures. I am citing these examples because I want to tell the district councillor that in the past few years, we have also taken care of the sentiments of the local residents. When you look at the paper, it seems that we are just trying to facilitate business. However, I would like to highlight that these measures must be made by amending the law. So that's why we are putting this forward. As for this session, it will end at 3:15. After 3:15, we will have another hour, and then we hope that we can finish scrutinizing the amended regulation. We have actually completed the clause-by-clause examination. Helena Wong. Chairman, you may remember that at the panel we have discussed about the LLB and liquor license. And FSCH panel has also put together this comparison report. We also held a meeting to discuss this. Now, for the two regulations tabled, now it is suggested that the license period will be extended from 1 year to 2 years. We've also heard from the district councillor that local residents may not be happy about this, and it may be even more difficult to regulate the premises. Well, for the whole issue of liquor license, other than validity period, there are also other problems. They include LLB members, and now the enforcement agency is the police. However, noise is not under the jurisdiction, so it's all scattered. So there was a case in which the Wan Chai police officers were involved in a corruption case. So the whole structure is problematic. These two regulations are they cover a very narrow area. We are just extending the validity period. But how about the composition of the LLB and the other relevant problems? They all appear in this report. So are we not going to tackle such problems, or you are going to handle these problems with other amendment regulations? With regard to LLB members, they come from different walks of life. We think the present composition is conducive to the discharge of duty by the LLB, and the LLB can be a gatekeeper for public interest because its members come from different sectors. We do not plan to change the composition. As for the police officers' case, the LLB chairman has explained in person to members. He has written a letter to the police force asking the police force to handle this matter seriously. It has nothing to do with the vetting procedure of the LLB. As for noise nuisance, if there is a problem, the Environmental Protection Department will do something. When the LLB imposes licensing conditions, if it finds fit, it can add a condition asking the operator to abate noise nuisance, and it can also limit the operating hours of the premises. This practice is already in place. So we think that the LLB is playing its role properly, and it has balanced the needs of the sector as well as the aspirations of local residents. We think a balance has been struck. And later on, we will be going to the panel again to brief members again on this issue. Dr. Wong, we are now scrutinizing 2 regulations. Let us not ask questions about the policy, because that is not an efficient way of using our meeting time. Chairman, I think these issues are related. At the panel, we discussed this. Well, if this should be discussed at a panel level. Today, we are looking at the 2 regulations. Well, these regulations cover a very narrow area. Now you are just changing the license period. So I'm asking related questions. That is for the other issues. Will the government be handling them on another platform?
Mr. Wong, well, on this issue, we will in due course brief panel members. Well, Chairman, in the study, there are issues that we're concerned about, and I urge them to go back to the panel and report to members as soon as possible. Well, at the panel, there are many questions asked by members. I don't know whether, and there are many items to be discussed. I don't know whether this is really urgent. Mr. Yu-ming, I'd like to ask Mr. Chi-fung. In fact, with an annual review mechanism or annual renewal mechanism, local residents can come and give their views every year instead of having a midterm review in which the local residents may not be able to give their views. Now, I'd like the government to explain in a moment. I'd like to know the difference between an annual renewal mechanism and the midterm review mechanism. From your experience or from your perspective, are there differences? Mr. Hui. Now, once a year is not really desirable because we can only have one chance a year. In fact, we should be able to complain anytime we want to be dealt with immediately. And we can only tell the LLB once a year that we've complained 300 times for the past year. And in the midterm review, there won't be any public hearing. And for cases with no enforcement actions or substantiated complaints, then without the need to have a hearing, the renewal application will be approved. This is really problematic for the district because local residents won't be able to make complaints. So I think the mechanism should be this. We should draw reference from the existing complaint mechanism or appeal mechanism of the LLB, and that is as long as there are 20 signed complaints within the 400-meter area, then the LLB should hold a hearing at the appropriate time or in a timely manner. And if we follow this mechanism, then I agree that the validity period could be 2 years or more. So what is the government's response in this, on this point? Does it mean that the midterm review is useless? Mr. Wong. Thank you, Chairman. I want to point out that for premises with license of more than up to 2 years, they should be having a good track record for the past 2 years. Not all premises are eligible for the 2-year license. If they're able to have a 2-year license, that means they have had a good performance record. If they did not, they would get a less than full-term license, say 1 year or less. So if it's 1 year license, then there won't be any difference from what is happening now. I want to point out about the midterm review that the use of a midterm review is that after granting a 2-year license, we cannot exclude the possibility of deterioration in performance, even though the premises may have a good track record. And that is why we propose to impose the midterm review, so that when the performance deteriorates, local residents don't need to wait for a long time before their complaints can be heard. That is why we've proposed to have a midterm review mechanism. And if in the midterm review mechanism the premises is found to have deteriorated in performance, then the government and the relevant departments will take action and the whole case will be reviewed. I reiterate that for any liquor license premises, if it is the subject of many complaints and many substantiated complaints, we believe there is little chance for the premises to get a 2-year license. Any follow-up? Just now, Mr. Hui said that, if there are 20 local residents, and well, the definition of residents is actually arguable. Whether the residents are living in that building or in the district. Definitely, those living in the same building will be affected. Let's say if 20 residents living in that building lodge such a complaint, then would that be a good idea? Or how about residents not just living in the same building but in the area? Will you accept it, Mr. Wong? As far as complaints are concerned, we don't impose any restriction. Well, it depends on the substance. I don't really understand your question. Well, in fact, I should interject and help. Anyone who wishes to complain against the premises about noise or other matters, they don't need to wait for a year. They could just ring the police, and the police would visit the premises within 24 hours. So it is not right to say that the local residents cannot make complaints. And we also have a judicial review on the LLB's decision to grant a license, the period of the license, and this judicial review mechanism can be used by either party. So it doesn't mean by amending the regulation that local residents have to wait for 2 years before they could complain. They could complain at this very minute. And I also have this experience. Say, if a premises has a 1-year license, then if it's a subject of a complaint of nuisance in the neighborhood, then even during the license period, a hearing can be held and the license can be revoked. Mr. Sin Chung Kai, well, I want to complain that, Chairman, you should sit on the other side. Because you may be more familiar with the issues than them. Well, I wanted that too, because I have just meager pay on this side. Now, last time we talked about License A and License B. License A means that we should stay put and maintain status quo. And License B means that you should have a good track record of 3 years without any complaints before you could get a 2-year license. Now, you say that the procedure would be automated, but in your mechanism, there is nothing to strengthen the complaint aspect. You say that the other party could ring the police every day. On the one hand, it's been made more convenient by changing the license period from 1 to 2 years. Many restaurants, many catering establishments may not have any complaints, so that's all right. But for the other side, I think there is an imbalance. For those which are subjects of complaints, there is no way to deal with them. So, P.S. if you don't have anything to enhance the complaints mechanism to allow complainants to make complaints more easily, then it can't do. Mr. Chi-fung has written in. I don't know whether you have his submission or not. I think the government should consider it. Of course, if you don't consider it, we could consider proposing amendments. And we could also just oppose all your proposed amendments. Do you want him to answer? Chairman, I want to emphasize that in order to get a 24th-month license, the premises should have a continuous good track record. That is, if the premises is a subject of complaints, frequent complaints in the past, I don't see how the premises would get a 24-month license. So the system remains the same. Well, Chairman, of course, maybe it's my fault. I really don't see that in the paper. It's not in the provisions. Well, now, your paper is one thing, but I'm talking about your regulation. Your regulation doesn't specify that. My question is very clear. Maybe I am not competent enough. I just don't see that. When the case goes to court, the judge may say that it's not in the regulation. So explain to me, Mr. Wong. Well, in the regulation, the LLB is required to consider 3 things: whether the licensee is a fit and proper person, and also whether the premises is suitable for selling of intoxicating liquor, and number 3, whether it is in the public's interest. So a balance has been struck. Well, in fact, I've made my point. I don't want to waste time. What I want to say is Deputy Secretary's remarks just now aren't reflected in the regulation. That is, for a premises which is a subject of frequent complaints, there is no way the premises would get a 24-month license. Now, the regulation's provisions are very clear. And from past experience, it is clear that for problematic premises, the LLB will not grant a full-term license. Well, although this may not be expressly provided for in the regulation, but it is fact that the LLB would only give a less than full-term license for those problematic premises, like 6 months or 9 months. Mrs. Sin Chung Kai. Well, if this is your policy, we can't support you. Because your policy is not reflected in the provisions. Although it's in your paper, it's not in the law. So what factors should be considered? I'm not saying that the LLB will act against your will, but they could. Maybe they say that the license should be granted on exceptional circumstances, since it's not expressly provided. So what will happen then? Should we ask the residents to beseech the LLB? It's the director of Bureau who appoints chairman and members of the LLB, so the Bureau can do something about it. But I understand your point. It's not written in the regulation under what circumstances a full-term license of 2 years can be granted. So the existing system is that the LLB can give a less than full-term or shorter than full-term license of 1 year, but not more. Mr. Wong Ting Kwong, I think there is only one issue here. That is to extend the maximum validity period of a liquor license from 1 year to 2 years. Now, there are different views, much of them having to do with bars and restaurants causing nuisance to the neighborhood. But we have over 6,800 liquor licensed premises in Hong Kong, and these premises include bars as well as restaurants and hotels, which are establishments not prone to causing nuisance to the neighborhood, and they actually account for 80 or 90%. And we just sacrifice everyone for the sake of a few. I think the extension of the license duration from 1 to 2 years would greatly facilitate the business of the sector. I also note that in relation to issue and duration of licenses in Section 20 of the regulation, in subsection 3, it says a liquor license shall be valid for a period of 2 years or such lesser period as the board shall determine. That is to say, we're talking about a maximum of 2 years, but the board can grant a shorter than full-term license.
So I think the LLB should talk to us about its policy on another platform, for example, the panel. Now, what kind of criteria would the LLB adopt when it decides on the length of the validity period? I think that should be discussed on another occasion. Today, we are having a subcommittee which would look at the regulations. So for the policy, I think it should be discussed at the panel. I think most of the operators would like to see a more business-friendly atmosphere. But of course, we have to strike a balance when it comes to nuisance caused to the public. But this should not be discussed here at the subcommittee level. We should be discussing the relevant policy at the panel. And we shouldn't be expanding the discussion here because we are not given the power to change other pieces of legislation. Mr. Kwok Wai-ka. Thank you, Chairman. As Mr. Wong Ting Kwong said, today we should be focused on the discussion of the validity period. Now it will be extended from 1 year to 2 years, so we should be looking at the midterm review mechanism. If you just stick to 23(1)(a), then it is not appropriate. because now you will be extending the validity period from 1 year to 2 years. So for the neighborhood which might be subject to nuisance, it may have to wait for a longer time before it can express its views. So for 23(1)(a), can you add something else? For example, if it's extended to 2 years, well, actually, for most of the cases, there are not much controversies. We are just talking about a small number of cases. But of course, we have to look at such cases. We cannot turn a blind eye to them. So why don't we do this? Can the government tell us more clearly? Now, if we allow you to extend it to 2 years, then at the midterm review, would you do anything else on top of the existing practice? For example, if you receive complaints, will you hold a hearing, and the hearing will be given the power to decide as to whether the license will be revoked or not, or suspended or not? Now, this is the second meeting. I've been listening to you. The government has been telling us that for those meritorious cases, we shouldn't waste time handling them. But for the deputations to attend today's meeting, some of them think that the government is just doing this to facilitate business, and you turn a deaf ear to the voices of the residents, and you just want to save the operating cost of the LLB, and you want to reduce its workload. Yes, I can understand that. However, now you are going to extend the validity period to 2 years, so you should also take care of the concern of the local residents. Ms. Young? Now, for the existing regulations, that is Dutiable Commodities Liquor Regulations, Clause Regulation 23, the LLB has the right to suspend or cancel a license if there is a breach on the side of the licensee, or if the licensee is no longer a fit or proper person, or the premises have ceased to be suitable for selling intoxicating liquor, or the public interest so requires. So if there are complaints, and if such complaints are substantiated by a relevant department, then the department can make its view known to the LLB so that the license can be suspended or cancelled. Well, according to Ms. Young, nothing will be changed. You are saying, you are talking about Regulation 23 ABC. Well, these are more serious breaches. But the problem we are facing now is that the local residents find it a nuisance. They are troubled by the noises caused. We do not want to revoke its license. We just want it to behave and abate the noise. If this cannot be done, then the concerns of the local residents cannot be addressed. Please turn on Mr. Wang's microphone. Even though it's a minor breach, if it is substantiated, then 24-month license will not be granted when it applies for renewal. And as I said just now, residents can lodge complaints anytime. To get a 24-month license, you need to have a clear record for 2 years. And if its performance gets poor, then in the mechanism, this will be reflected. And even in the middle of the validity period, the license can be suspended. If the breach is minor, we will still do something. and this will definitely affect its future application for renewal. So I think we are all talking about the same thing. That is when the LLB discharges duties, whether it will strike a balance. And I can tell members that, yes, we can discuss this again at the panel. That is whether a proper balance has been struck by the LLB and whether improvements can be made. And this can definitely be discussed again at the panel. And it has nothing to do with the validity period of 12 months or 24 months. Ms. Young, do you want to add anything? Second round, Dr. Elena Wong, 3 minutes. Please do not talk about policy. Chairman, because the policy is totally related to the regulation, how can I not talk about it? For this paper, in the annex, we can see the number of complaints in Central and Western in the year 2014. Of 218 complaints were received, and Yaochim 302, Mongkok 198, and even for Typo 259. So for these premises, were they successful in renewing the licenses? When the LLB considers granting a renewed license, how would these complaints be taken into account? These figures haven't told us anything. So if complaints are complaints and renewal are renewal, then nothing would change. According to Mr. Wong, if there has been bad records, then the new validity period will not be as long as 24 months. It will just be 12 months. So these recidivists, or are these just one-off complaints? Monsieur, all along, when the LLB handles controversial cases, for example, when residents, police, or district councillors object to a certain application, then a public hearing will be held. The applicants and the objectors will be invited to the hearing. Views will be heard from both sides, and then a balance will be struck. The LLB will decide as to whether the application will be granted or rejected. And also the LLB can decide whether the validity period will be 1 year or for a shorter period of time, and whether additional conditions should be imposed. For example, if noise nuisance is involved, then the LLB may restrict the operating hours of the premises, or the amplifiers operating hours will be restricted, or there may be the premises will be asked to close their doors after a certain hour, etc. So can you give us the figures and give us more information concerning how LLB has been handling such cases? So even though there have been complaints, the LLB will still grant licenses? Well, after receiving complaints, a public hearing will be held. The LLB will listen to views from all sides, and then a balance will be struck. The LLB will look at the interests of the residents, and it will also look at the interests of the businessmen. Then a decision will be made as to whether the license will be granted. In 2014, there have been 8,223 applications. They include renewal, new applications, and transfer of license, etc. And as for controversial cases, there were 1,900 cases. The government, LLB has rejected 67 applications. Now, maybe the applicant is not a fit and proper person, or the premises are not appropriate, or is against public interest. Mr. Sin Chung Kai, second round, 3 minutes. Chairman, I would like to ask the Secretary or the Permanent Secretary, would you consider including the points you made in the law? That is, if there has been no breach in the past 2 years, then you may consider giving the applicant a 2-year license period. And if in the middle of the license period there is complaints, the license may be suspended. Now the policy is changed, so this should be included in the law. Otherwise, I cannot support the regulation, the amended regulation. Now you have the policy. Why can't you set out this policy clearly in the regulation? If you include this policy in the regulation, there will be advantages for those premises that are not subjects of complaints. Well, as you've told us, most of the premises are not subjects of complaints. So then you can focus your efforts on those controversial cases. Otherwise, all the applicants will get a 2-year license automatically. Can it be included in the law? Chairman, we think that the legal framework is broad enough, and the LLB would have to take public interest into account. We understand Mr. Sin's concern. An expedient way of doing this may be like this. Now, when the LLB vets applications from upstairs bars, now it has a set of guidelines which is open to all. If there is a need, we can talk to the LLB. That is, under what circumstances would a 24-month license be issued? Another set of guidelines should be drawn up so that you can monitor the work of the LLB.
But Mr. Sin's point is that he is asking you to put it in the regulation, and you cannot do that. Right. So, Mr. Sin, you may continue to object. But they're saying that they could do something about the LLB, and then in fact, members of the LLB do follow some established practices. But we're not here, Chairman, we're here to scrutinize the legislative proposal. So you ask whether they are going to do it or not, and the answer is they can't do it. That's it. Dr. Helena Wong, your question? As a member of the subcommittee, if the government is unwilling to put in the regulation the actual criteria for operation, I'm not going to support that. I am going to move a CSA to include the criteria or the considerations for whether to grant a license or to renew a license or not. So please remind me, Chairman, when is the deadline for moving amendments? 5 whole days for moving amendments in advance. That is the 18th of March. When will the second reading be resumed? We have extended the period to the 25th of March. All right? I already extended the scrutiny period to the 25th of March, and you are to submit amendments before the 18th of March. So, yes, Dr. Helena Wong, to facilitate our preparation of CSAs, may I ask Mr. Christopher Wong to give us the guidelines for LRB to consider whether to grant or revoke a license or not. Please give us that guidelines. Mr. Wong, I believe they do have this guidelines. Mr. Wong? Well, there is a set of criteria for public's reference. That is so there are criteria, but not a code of practice, so to speak. There are guidelines. The guidelines are available online, and it's also annexed to this paper. Now we'll go back and talk to LRB and see whether they could explain clearly under what circumstances a full-term license of 24 months can be granted. In the paper, in one of the footnotes, we have set out the criteria which we believe would, if met, would merit a 24-month license. And this is footnote number 1 on page 3 by good track record. What cases we're referring to. And the footnote is actually prepared after discussing with the LLB. In fact, by making reference to the criteria, I'm talking about footnote number 1. And we can talk to LLB and see whether this part can also be included in the criteria as well. Mr. Sin Chung Kai, I don't know what you're trying to ask, but two of you just keep asking questions, and I don't want our deputations to be here to listen to all your questions again and again, because we have to move on to another issue. I thank deputations for attending the meeting. You may be excused, and we are going to move on to another item. The government, on the 17th of February 2015, gave a reply to the issues raised at previous meeting. And at the meeting on the 17th, we completed scrutiny of the 2 amendment regulations. Members raised various concerns and issues at the meeting and asked the administration for written reply. And on the members' concerned, I asked members to refer to LegCo paper CB bracket 2913/1415 bracket 03. The government's reply can be found in LegCo paper CB bracket 2913/1415 bracket 04. The relevant paper has been forwarded to members before the meeting. So, Deputy Secretary, Mr. Wong, do you need to walk us through the paper for discussion by members, please? Ms. Wong. At the last meeting, in response to members' concerns, we have prepared a response. The first question is about premises with good track record. We are to give a breakdown of such premises. There are 6,800 liquor license premises in Hong Kong, over 90% of which have restaurant licenses, and less than 20% have bar endorsement. Last time in the paper, we also mentioned what the criteria for good track record mean. Now, in relation to liquor license premises as at the 31st of December 2013, about 78% of them will meet the test. And based on the 2013 data, about the breakdown of premises with restaurant licenses and bar endorsements, the percentage figures are similar to those I mentioned just now. The second issue is about the number of complaints received and substantiated against liquor licensed premises in various districts in the past 3 years. And the relevant information is in the annex, and members already referred to it just now. Point number 3, existing cost recovery rates of new issue and renewal of liquor licenses and the costing methods. And we've been asked to provide some information. About new issue and renewal of liquor licenses, the cost recovery rates based on the existing procedures are 25% and 149%. So that means for new issue, the cost recovery rate is lower, whereas for renewal is much higher. The cost computations are based on the prevailing costs of the requisite work procedures involved in the related resources required for processing the new issue and renewals. The costs include staff costs, departmental expenses, accommodation costs, depreciation, cost of services provided by other departments, and central administrative overheads. The other point is this. After rolling out the proposal of extending the maximum validity period of a liquor license, what is the estimated savings in overheads on a departmental basis? Now, in supporting the LLB's deliberation on applications for a 2-year renewal, the Liquor Licensing Office would take into account the regulatory records in relation to the applicant's operation, including complaints and enforcement actions. This will form part of the midterm review. The cost arising from the establishment of the midterm review mechanism is expected to be outweighed by the reduction in workload that would otherwise arise from the processing of straightforward license renewal cases annually. Point number 5. Now, as members have noted, the reduction in the projected cost recovery rate of license renewal will be reduced from 149% to 119%, and they asked for the reasons. Now, under the proposed fee of 2-year license, which would be set at 1.5 times of that for a license that is valid for 1 year, a licensee will actually pay less for renewal of a term of 2 years as compared to the existing mechanism. The annual revenue is expected to drop, and there will be costs arising from the midterm review mechanism, although it is expected to be partially offset by the reduction in workload. So altogether, as far as license renewal is concerned, the cost recovery rate, due to various reasons, will be reduced from 149% to 119%. So this is in response to the issues raised by members last time. Thank you, Chairman. Mr. Ray Chan, 5 minutes. I'd like to follow up on the cost recovery and user pay principles. Last time, I recall, when I asked, Chairman, you told Ms. Wong that you estimated the cost recovery rate to be 50 or 60%. Yes, that was just my estimate. I don't know how the 25% and 149% come by. 25% is for new issue. Perhaps a high cost may be involved. You need to process the application. You need to do inspections. But according to the Financial Secretary's adherence to the cost recovery and user pays principle, you should be able to recover costs fully, up to 100%. So, in the near future, will you raise the fees to recover costs fully? Can you explain why it goes beyond 100%? Is it for making a profit? Or is it because you just follow the established practices and things got smooth, and therefore the percentage gradually goes up to 149%? Or did you set it at 149% at the outset? Now, Chairman last time said that he estimated to be 50 to 60%. In fact, that's also correct, because that's actually an average of new issue and license renewals. And we plan, in fact, after summer recess, to report back to members, panel members, on liquor licensing matters. Now, point number 3. In fact, for a license renewal, the workload involved is less than that for a new license. Now, the cost recovery rate is 149% at present, but after rolling out the new proposal, it will be reduced to 119%, so quite close to 100%. So maybe towards the end of the year, when we come back and report to members on the revision of fees, we will talk about that. My question is it your principle to make money by raising the percentage to 149%? Now, if it's for a 2-year license, the rate is 149%, then the government won't be suffering any loss. But in fact, for a less than 2-year license, I mean, say for 1 year, you should reduce the percentage. Well, that's why they are setting the fee at 1.5 times the existing level. That's the fee for 1 year and a half, not a full 2-year period, so that there'll be a mutual benefit for the government as well as the sector. Is it because your work gets quite sloppy when it comes to license renewal and you can save manpower and reduce workload? I don't think so, Ms. Wong. We do charge a fee for renewal, but the fee, I mean, the cost involved is lower than that for a new issue, and as a result, the cost computation tells us that it's 149%. But in fact, we have a financial commitment of $2.7 million. So will you draw a line at 100% so that in the long run you will lower the percentage? If in the long run there is no need to make money, they could reduce the fees and license fees. And of course now they also face pressure because we'll exert pressure on them. Well, in the end of the year, when we brief members again, we can then discuss how we could push the rate down closer to 100%. But we should bear in mind that the overall principle is to recover costs. As to how we can push the rate from 149% to 100%, then, well, yes, this can be done, but the figure would be quite an odd number, not 1.5 times perhaps. Well, for new issue, because you have more frequent inspections, the cost may be higher, but the cost actually is borne by the police, not by them, because they have to do the inspections, not the office. In fact, every license check is conducted by the police.
Well, because their officers will not work at night, and most of these premises would operate at night. Yes, I know that, but if the procedures get more complicated and if they are more stringent, then of course the cost will be higher. So yes, if there are more complaints, then the workload will be heavier. They have to do a lot of paperwork. Mr. Sin Chung Kai, Chairman, I would like to ask our legal advisor concerning the whole legislative procedure and the movement of CSAs. Legal advisor, about CSA timetable, as I told you just now, is the 18th of March. If we are going to extend to the 25th of March and we need 5 full working days, this is this regulation is undergoing a negative vetting. So what's our voting procedure? Legal advisor? This regulation is subject to negative vetting. This is a subsidiary legislation. As the chairman pointed out just now, the notification date will end on the 18th of March. If members want to move amendments to these 2 regulations, then you have to give us the CSAs before the 18th of March, and we will work in accordance with the negative vetting procedures. On the 25th of March, it will be discussed at the council meeting. Yes, we have extended the period to the 25th of March. So this will be voted on at the council meeting. Well, are we not going to handle the budget on the 25th of March? No, that will be in April. Our special FC meetings will start on the 27th of March, and the deadline for that will be 24th of March. So for the 25th of March, it will just be a regular meeting of the council. You don't have to raise your hand all the time. Now it's Mr. Sin Chung Kai's time. Well, I have seen you raise your hand. You don't have to attract my attention all the time. He hasn't finished his questions. After he has finished, I will let you ask your questions. Chairman, if we cannot wrap up our discussion by the 25th of March, what will be the consequence? Then we can have another extension. Can the legal advisor answer me? Legal advisor. Thank you, Chairman. The Chairman has already moved a motion for extending the scrutiny period, and there is a deadline for these regulations. After the extension, the deadline is on the 25th of March. Then after the 25th of March, these two regulations would have already come into effect. Well, this is a piece of subsidiary legislation. So if that's filibustering, then it will come into operation automatically on the 25th of March. On the 18th of March, we have a council meeting as well, right? 18th? Yes. Is it before the resolution or after the resolution? What's the normal order? What do you mean? On the 25th of March, you mean when this will be discussed at that council meeting? I think it's after the Q&A. Of course, you may not trust me. You want to ask legal advisor? How would the legal advisor know the order at a council meeting? Well, as you like the legal advisor so much, well, I'll let her answer you. Well, Chairman, I know you want to sit on the other side, but if you want to be the secretary, I think you have to wait. Now, for the, well, if you want to move a CSA, then it's a member CSA. According to the procedure, I think in accordance with Rule 18, there is a order. And if it's a member's CSA, I think it would be ranked lower. Is it, can we do it on the 18th? No, before the 18th, you have to give it to us. So after I give my CSA to you, when are we going to vote on this? 18th or 25th? Must it be on the 25th? I believe it's the 25th. Legal advisor? For this subsidiary legislation as to when it will be voted on, I think CB3 would have to make the decision. Maybe it's the 25th or a Wednesday earlier. And I think colleagues in CB3 will make a decision on this. Now, we always remind you when you should do this, because after you put together your CSA, the legal advisor may have to redraft it. I'm worried that the Secretary for Innovation and Technology, no, sorry, we now do not have a Secretary for Innovation and Technology. I mean, the I mean, Mr. Greg So, he said that on the 18th of March he will come again. And some of our colleagues indicate that they will filibuster again, and that's the government's resolution. So for a member's motion, it would be after the government's resolution. So we will be affected by filibustering. Maybe I can supplement. For a subcommittee looking at a piece of subsidiary legislation, after the scrutiny, it would have to report to the House committee. So for these two pieces of subsidiary legislation, now is extended to the 25th of March. That is, it will be voted on the 25th of March. So a report would have to be made to the House committee on the 13th of March. And then the deadline for notification would be the 18th of March. So can the motion be moved on the 18th of March? Then you have to count 5 days backward for notification. And on the 6th of March, there will be no House committee meeting. So a report cannot be made to the House committee on that day. If you are worried about the Innovation and Technology Bureau, and Mr. Gregory So will be making another speech, and then there will be filibustering, and this regulations will be hindered, then maybe you can talk to your colleagues so that there will not be filibustering. Dr. Helena Wong, it is our duty to scrutinize bills and regulations. Now, if this is to be voted on the 25th of March, can we assure that it can be handled at that meeting? And if we cannot do this on the 25th, then on the 26th, it will be too late. It's already lapsed. Well, last year we had this experience. Your party and my party have both said that we do not like negative vetting. For legislators, this has actually undermined our power to scrutinize bills. Unfortunately, now we have this negative vetting mechanism. Just now, the clerk and the legal advisor have both said that, well, this would be handled on the 25th of March. And if you veto it on the 25th, then it cannot take effect. So if the council meeting is supported that day, and if Mr. Ray Chen asks for the counting of members, whether there's quorum or not, then the meeting may be aborted. And then it's Easter. The regulations will come into operation automatically. We don't have to discuss it anymore. It's the same thing as what happened to the ban on baby formula. You can do whatever you like, but nobody can guarantee you that your CSA will definitely be voted on the 25th of March. Nobody can tell you exactly. Chairman, we are members of the subcommittee. Can we talk to the president and ask him to put this a bit forward in the agenda on the 25th of March, because otherwise it will come into operation automatically. Clerk, the legal advisor has mentioned that according to Rule 18 of the Rules of Procedures, the order of the council meeting has to follow a set of rules. So what are those rules? Does it mean that we cannot vote on this on the 25th? No, that's not true. Every week we do the same thing. That normally after Q&A, you have second reading, third reading, and then resolution, and then motion. Motions would be put at the end, but sometimes you may have an urgent oral questions, so that would also take up some time. So there is an established order. You cannot ask the president to advance this. There are rules to follow. We cannot guarantee you that this will happen according to your wish. I would also like to ask a question about the annex. Now, for the complaints received and the complaints substantiated, it seems there is a huge gap. So who's going to substantiate the cases? Is it the police or the LLB? Ms. Young? Relevant departments. Now, for a complaint received, if it is against noise, then it would be the EPD. If it's about road obstruction, it would be the police. If it's illegal extension of business area, then it's FEHD. So it depends on what the complaint is about. So how come most of the complaints were not substantiated? Monsieur? So once we receive a complaint, the relevant department will go to the site. For example, if it's an unlawful extension of operating areas, then FEHD will go visit the site, collect evidence, and if the complaint is found to be true, then enforcement action will be taken. So we have to do a site visit and collect evidence. I can give you an example, but your colleague may not be happy with me saying that I should be sitting on the government side. Now, if a person complains about noise, then he would call the EPD or the police. And EPD sets the limit at 85 decibel, and it has to last for a certain duration of time.
So a noise might have been made, and I got woken up, and then and yet there is no way to substantiate the complaint. But we need somebody to take the measurement to make sure that it is in breach of the regulation. So, Chairman, you're right. So if this is substantiated, would it be regarded as a poor track record? Well, if the complaint is substantiated and 24 months immediately before the renewal application, there is such a substantiated complaint. No, I'm talking about a complaint but not substantiated. Then will you still give it the 24 months license? Now, if it's not substantiated, then there is a chance that the premises will be regarded as having good track record. But then that's the problem, because they may be making great noise, and the EPD staff may not work around the clock. In the middle of the night, nobody would come. Well, in fact, I can tell you that that's not the case. When there are loudspeakers, they won't switch it off until the police arrived. It's not like selling dangerous drugs. Now, you should let people know what good track record means. Now, it says here that it's either written warning, verbal warning, or prosecuted. A complaint is regarded as substantiated if enforcement action has been taken against these. Now, Ms. Young, now can you supplement? Let me supplement. Good track record is a criterion for application, but there are other factors. In fact, on page 3 of the electrical paper, footnote 1, point C, if there are objections or adverse comments from the public, then this may destroy the good track record and may cause the license renewal application to fail. This is just one of the 3 criteria. No more questions? Mr. Sin Chung Kai, I see you're about to raise your hand. This is exactly our concern, because if we need to show that the complaint is substantiated. Very often residents complain, the police came, and then the complaint was not substantiated, and then the premises would get a good track record. On page 2 of our ROP, I have a question for our Secretariat about the order of business. I think this is about motions moved in relation to subsidiary legislation or other instruments, and I think we will be following this order. But whether this will be debated that day will be subject to fate. Well, that's the same case as we had in the past. Sometimes you may have you may have PNP. In accordance with Rule 18 of the ROP, JB means that the member, in relation to a piece of subsidiary legislation or other regulations, the member may move a motion, and basically this is after the government's motion. So if we are to move amendments, we should follow this. That's in relation to the order of business of the Council. All right? All done? Dr. Helena Wong? Another question. Page 3. Footnote 1. Good track record. C. It says do not receive objection or adverse comment from the public from its license renewal application notice. But just now, you mentioned that when there are complaints that are not substantiated, they will not be regarded as not having a good track record. What about complaints or objection from the public? I want to explain once again that by good track record we mean no complaint and no prosecution immediately 2 years immediately before the license renewal application, and only when that happens would the LLB consider this as a good track record. And in considering the application, apart from point A, we have to consider point B, that is, it should have been granted a full-term license, at present being 1 year, at the time when the licenses were last approved or renewed. And when processing the application, in the meantime, if the LLB receives complaints or objection or adverse comment from the public, the LLB is unlikely to give a 2-year full-term license to the premises. But what you say is different from what's said in the paper. In the paper, you said that only when no prosecution or warning have been received would you give a 2-year license. But here in the paper, you say that if it doesn't receive objection or adverse comment from the public from its license renewal application notice, a full-term 2-year license will be granted. But in fact, the system is the same. An advertisement should be made to make known the application process for the residents living nearby to make objections. And if no adverse comment or objection is received after publication of the license renewal application notice, and only by not receiving such objection and adverse comment would the application be considered having a good track record. But what about complaints substantiated, not substantiated? Here, this won't be regarded, or this won't be included in considering whether it has a good track record. for complaints received in ordinary times, if they're not substantiated, they won't be regarded as adverse comments. If they're substantiated, they will be regarded as adverse comments. When we look at a case, we look at the track record over the past 24 months. If there is one single complaint that is substantiated, then probably the premises won't be granted a full-term license of 2 years. Can you clarify? Because what you say is different from Ms. Young's version. Ms. Young just now said that only if the premises hasn't been prosecuted before would it be given a 24-month license. And just now you mentioned adverse comment, and adverse comments would include verbal warning. I want to remind Dr. Helena Wong that substantiated complaints don't necessarily mean prosecution. I think there are 3 different things. 1, complaints, but not substantiated. Unsubstantiated complaints, that is to say. 2, complaints that are substantiated. 3, prosecution. So there are 3 different levels. No, more than that. Substantiated or unsubstantiated complaints. And there are 3 things here. Prosecution, written warning, verbal warning. 3 things. And you're saying that you will only deal with those premises which have been prosecuted before. I don't think that's what Ms. Young said, but please clarify. I talked about prosecution. I raised the example of illegal extension of shopfront, and this is the work of the FDHD. Dr. Wong, you're right. In fact, apart from prosecution, written warning or verbal warning would all be regarded as substantiated complaints. So, as long as those complaints are substantiated, you won't give a full-term 2-year license, right? Because substantiated complaints don't necessarily mean prosecution. Substantiated complaints and warnings will be regarded as substantiated complaints. But it doesn't mean that whenever there are complaints, a full-term 2-year license will not be given. So during the renewal application, verbal and written warnings would be included when considering the performance record, and that the 2-year full license will not be granted. So under what circumstances would the license be revoked? And that's in accordance with Section 23, the 3 conditions. Not a suitable premises, the licensee not being a fit and proper person, and also the relevant departments having informed the LLB of the situation. The LLB can then consider whether to revoke the license. Mostly these are cases involving major breaches. Mrs. In Chung Kai, just now, the legal advisor informed me that in fact the 25th of March is not really the deadline. In fact, it also covers the 26th and 27th. So that means we can still deal with the motions before the 27th midnight. Am I right, legal advisor? Now, the extension actually is for the council meeting on the 25th. So if the council meeting spills over to the 26th and 27th, the scrutiny period is still valid, but not in the case if the meeting is aborted. All right, then I get it. So a report will be made to the House Committee. I want to indicate that I'm going to move an amendment. Please include this in your report. We'd like to move amendments in relation to footnote 1, policy matters. We want them to be included in the regulation. We don't want to be in the way of restaurants that are not really subject of complaints. But in fact, it's really controversial what complaints mean, because most of the complaints are not substantiated. Would you think that residents are just fooling around since they have nothing better to do to ring the police? No, they complain, but when the enforcement officers arrived, the complaints are not substantiated. You do paperwork in your office. It's not the same as residents really living there being subject to noise nuisance. So we're going to move the amendment. Dr. Helena Wong. Chairman, to facilitate our work, I'd like the government to give us a breakdown of figures. First, the breakdown of complaints. How many prosecution, how many verbal warnings, how many written warnings, and also over the past 3 years, how many complaints were substantiated, and consequently, the renewal applications were rejected. For our information, and please tell us how the LLB would strike a balance to safeguard public interest. The specific guide for the LLB in considering public interest. Please give us information. I don't know if Ms. Young could do everything or not, because you have asked for so many things. It's before the 18th of March. Do you have a date in mind? When before the 18th? Because you're to submit the amendments before the 18th. Would you require these figures to be available before you submit the amendments? Well, Chairman, of course, the figures should be ready before we submit the CSA before the 18th, before going to the House Committee. That is the 13th of March, is that right? Ms. Young, is it okay?
Well, if we already have the information that can be given to you, but some may involve the LLB and we may not have the records. So those may not be provided to you. So it must be done before our House Committee meeting. But anyway, you will be moving a CSA, right? So please pay attention to the date. Any other questions? If not, then we have already completed the clause-by-clause examination. We do not need another meeting. I would like to remind members. Chairman. Now, before we formally hand in the CSA, can we have another meeting? Because we will be able to get information before the 13th of March, and we may have to ask the legal advisor again. Now, you can draft your CSA. The legal advisor will revise them, and if we have time, we can hold another meeting. But when will your CSAs be ready? If you already get your CSAs today, we can look at them today. Last time, Ms. An Jiang also put together a number of CSAs at the meeting. So we do not need to have another meeting, because you can put together your CSAs and then you ask the legal advisor to look at them. Is that okay? So I would like to remind you about the days. The scrutiny period will end on the 25th of March, and counting back 5 days, the 18th of March, and I will have to report to the House Committee on the 13th of March. And your parties will be moving CSAs, right? I have told you roughly what my CSAs will be covering just now. So you can draft your CSA, the legal advisor will look at them, and then we will circulate them to members. Well, if you want to hold another meeting, I don't know when we can do this. Well, we will definitely do that before the House Committee meeting. So if there are no other business, we will adjourn the meeting now. Thank you.